There is beauty. There is beauty in who we are, not men and women, children whose souls go giddy when our souls' feet feel for the dew on fields of green where eyes stretch out to touch the morning sun, on a park where dreams are allowed to sleep. There is beauty in what we love. This part of Nairobi where love is allowed to pluck a rose, where the only estate that is real is your state of mind as it grasps for the only pure air in this city where it's a crime to breathe free air. That is the poem. There is beauty. I have not read the whole piece. You can find it on my site. That's kenyanpoet.com /blog. Welcome back to another episode of the Kenyan Poet Podcast. Now, in this podcast, our discussion is going to be on content creation, monetization, royalties, tax exemptions, privacy, and copyright infringement. And because I'm no expert in most of those, I have invited my good friend Wandiri Karimi. Now, Wandiri is the director, Kenya Conservatoire of Music, and she's also an intellectual property expert. So welcome to the show, Wandiri.
Asante sana.
Yes, it's really good to have you.
Good to see you again.
Yes, it is.
Yes,
after it's been quite a while. It's been quite a while. And I think the last event we were at was actually an event that had to do with music and musicians and music royalties.
It did. I was doing a training, and I think you're the one who invited me.
Yes,
Actually,
I am.
yes, you invited me, and I
Yes.
think for me, when I like I keep saying, I'm a musician who studied law. And the opportunity to put the two loves that I have, music and law, together was I think the reason why I was put on this continent, because I think one of the things that's very key for us content creators is that whatever it is that we dream up and whatever it is that we do, we get paid for it, because really art is wonderful. It's even better when you get paid to do it.
Oh yeah,
Yes.
yeah. There's a better feeling to that fulfillment than just feeling good because of sharing what you've created.
Exactly.
So before we begin, I'd like to just mention to those of us who are poetry fans out there that the longest running poetry event, that's a Kwani open mic, resumed this month. Actually, it was on Tuesday. That is when they had their first, I think, after like 2 years of taking a break. And it was such a wonderful event. The featured artist was Ngatia.
Yeah.
Yes, so that was really good. It was happening at the Wasani restaurant, that is at the Kenya National Theatre. And even if you want to catch any of the performances, you want to be back in the community of poets, then that is an event to look out for every first Tuesday of the month. As we get into the discussion, I'd also like to thank Unique Kenya for their support in making this episode and the entire season 2 of this podcast possible. So let's get right into it. After we've paid our sponsor,
A word from the sponsors. Exactly.
A word from the sponsors. So I think we'll start with tax exemptions and what I was previously calling music royalties, and which you corrected me and told me it's actually more of content royalties. Now, about 2 weeks ago, I hope I'm not wrong, about 2 weeks ago, you forwarded me a video clip of news coverage that indicated that the National Assembly had exempted Kenyan artists and content creators from 25% excise duty, and that they have proposed that has been proposed to make an amendment in the Finance Bill 2021. So I don't know what that means. And just give us a breakdown of what exactly that means and why this ruling why that is significant.
Well, I think first of all, the way laws are made in Kenya, the parliament has to go through them, and then there has to be assent, and really everything where government is concerned has to be in writing. So it was. I was excited when I saw the clip, and then I had a chance to look at the Finance Act itself, and I am yet to see that reduced into writing, and I think one of the things that is very key when we are interpreting, whatever law it is. I'm not a tax expert. I'll put that disclaimer there, but the if it's not in writing, it's very difficult to convince any government official to implement something that is not reflected in an act of parliament and or a gazette notice and or any government instrument that instructs the officers to do so. So while the clip was exciting, in my research before this podcast, I am yet to see that exemption defined as that. We hope that is just it was maybe an omission. Maybe there's a following gazette notice that will reduce that statement into writing, or a directive, whichever way that it works, but it must be in writing, and I'm yet to see that. Yeah.
And this is 2 weeks into that media story.
Yes.
Okay. And is this something that has been known to happen? Like, there's news coverage about a certain bill that has been passed in Parliament, but then there's no gazette notice to sort of back that up.
Yes, it happens.
Okay.
It does
Okay.
happen. But taking us back, I mean, about 2005, 2006, there was an exemption of VAT for I think it was music services or entertainment services, and this was actually reduced into writing as part of the exemptions in the VAT Act. So my experience with these kinds of exemptions is that they are usually in writing, and so because it has happened before, my expectation was that there would be that exemption in the Finance Act, which is not there. It was gazetted on the 29th of June. So let's wait and see if there's going to be something. It's not, all is not lost. Let's wait and see.
Okay, so I'm not sure whether to be, all excited
Yes.
for content creators,
Yes.
because this applies, and so just to go back, does this only apply to one platform, and that's the Skiza platform, or does this apply to any content that is being shared on a digital platform?
Well, I'm in this particular Finance Act, there was an inclusion of Digital Services Act as part of an amendment to the income tax, and what that said was, if you are offering services on the Digital Services platform, then that Digital Service Act applies to you, and that will be offset off your income tax. So in my mind, I think there's this is a space for tax experts to have conversations with content creators, and we are many. I mean, there's the people making the comedy clips, the guys doing their TikTok, guys doing their influencing, whatever it is that they're doing on the digital space. It's good to sit with a tax expert to actually explain to you what that addition to the Income Tax Act means. For me, it's a good thing, because of course the government is recognizing that content creators on the digital space are actually a revenue stream. Now, for me, the thing for us would be to get lobby opportunities to have then conversations about being contributors to the exchequer, but then having conversations about having some of that plowed back into our spaces. Yeah.
Okay, and back to the excess duty, because I think when I was looking at this, my mind kept going to musicians,
Yes,
and music royalties.
Yes.
And so one of the things that I kept thinking about is what has been the current sharing formula or proceeds from ringback tone. So maybe we can focus on that, because that has
Yes.
been the main focus, and then sort of we'll move away from that and into the larger context of content creators, because from what you've said, this does not just affect musicians or artists, it affects all types of content creators. So
Yes.
let's start with the ringback tones.
Yeah. So when we started using mobile phones, there was a time there were no mobile phones. I didn't even understand the ringback
Concept.
concept. I
Yes,
didn't
you're
understand
entertaining
why I
someone
needed,
as they
yes,
wait for you
as
to
they wait
pick
for
your
you to pick the phone. But anyway, and then people started putting their names on, and that's the reason I was saying, it's not just musicians,
That's
it's
true.
comedians
And poets as
and
well,
poets
and
as well.
inspirational
Exactly.
people.
And the initial revenue split, of course, was not favorable. And there was quite a bit of noise, I think, around 2016, 2017. And I think there was even long discussions, of course, which I was not privy to. But the initial one was definitely not favorable. And it's still not favorable because a majority of what is, say, for the 1 shilling that you're paying, at that time, it was alleged that about 5 cents is what was going to the musician. And while that was still a sizable amount for those who had many people, using their content, how Conduit, which is the telco and all their partners,
Affiliates, yeah.
and then the tax component of it, and then the PRSP, and depending on what kind of deal that you had, a PRSP is a premium service provider. They are licensed organizations by CA, which is the Communications Authority, who are licensed to aggregate content and then offer it to the public. And yes, so they make profit from that. And they were keeping between the telco, the PRSP, and the artists, the bulk of the money was going to government, telco, and PRSP. And there were roundtable discussions, and the discussion at that time was to kind of move that from that 5% at the time to something at least to 30%. This was in 2017. Now the content creators, I guess, are the ones who can tell us whether this has been a little better for them, because again, even
Yeah.
even if you look at all the other platforms, it is the volume that you drive. So even if you have 1 million downloads, 1 million people listening to your ringback tune, then that means that your content is reaching more people, and therefore you're making more. But if you only have one person, then that one person that revenue is only 1 shilling per month. So you're still not going to, or is it no 1 shilling a day? It's 1 shilling a day. Yes, that's still not going to reflect. So it's really your popularity and how it is you get your content to the public. But yes, so there were those discussions, and there was, and at the time the push was to get that percentage as high as possible, closer to the 70-30, which is what the artists were pushing for. But at the time,
This is for 70% to the artist.
to the artist.
Okay.
That is what was being pushed. But then the discussions around that time became 20 to 30% for the artist. That is what they were working towards.
Okay.
But I mean, I guess on the comments and on we can hear what it has been for them.
Okay.
Yeah.
Okay. And still on this amendment, does the excise duty exemption only apply to the Skiza platform?
For I mean, there's nothing in writing right now in the Finance Act, so we will wait to see what that clarification is going to be. Because for me, without a doubt, content is king, and content is what we should be discussing moving forward. Because of course, with the pandemic and what we've realized about people consuming content at home, that is a conversation we must have. But those definitions need to be clear, because again, like you said, is it just the musicians? Is it just internet content? Is it also TV content? Where is the excise? There is so much definition. The thing about legal conversations is you must define everything, because if you do not define, or even if you don't define it, you must have a way of describing what you have not defined, so that
Yes.
the ambiguity is not there, and then we do not have a space where we are asking this question. Because you see, like as I said, in the Finance Act,
It's not there.
it's not there. There's no conversation about it. So how do we answer this question without
Yeah.
that clarification? Yeah.
Yeah. Okay. So as we are waiting and having the faith that by end of this month. We're in July, because for any content creator, the royalties are paid on a monthly basis, and so this is supposed to have taken effect by the
1st of
by the
July.
1st of July.
Yes, yes.
Okay. So so then my question was going to be, in case there is no gazette notice and there are no amendments, what then happens?
For me, we have to be able to have conversations as a collective group. I mean, as a collective, as collectively content creators, so musicians, comedians, whatever it is, whatever those groups are. And unfortunately, there are a number of lobby groups for the creative sector that have written papers, are doing research, and having direct conversations with the relevant government bodies, that that amendment is made, and whether it is moved either from the Ministry of Culture, or moved from the Parliament itself, or moved from whatever spaces in which we can get that amendment defined and put in, then I think that would be the way to go.
Okay. Now, a call for the amendment to the Copyright Act, which is what I'm forgetting the parliamentarian who had taken that motion forward. I remember it was a lady. Do you remember?
I don't remember her name, but yes,
Sorry,
yes.
I'm forgetting. But so she talked about a call for an amendment of the Copyright Act, which will see artists taking a bulk of revenue generated from the sale of ringback tones. So, what sections and which sections are this in the Copyright Act, and what would if like you were they were to come to you as the IP expert and copyright expert, because you have vast knowledge on the Copyright Act, and what would your recommendation be on the sections of the act that are to be amended, in which way? Because you sit as both as an artist and as an expert on this. Which of these amendments would work very well for musicians or even content creators?
Well, there was an amendment recent amendment in 2018, and the Copyright Act went through this whole amendment process. The parliamentary committee sat and had conversations about it. But then at that time, it was really about regulating the CMOs, and the CMOs being the collective management organizations, and that was a key driver of those amendments, where they were looking at how these collective management organizations are being run, and how they are distributing what it is that they're collecting. I think at the time also these payments that we're talking about, these royalties that we're talking about, were going through these collective management organizations. And I think an amendment to that space, because there is also a conversation around tariffs, and what your hotels, what your bars, and what your matatus and all that are paying. And those conversations have taken place between the CMOs, the collective management organizations, and the Kenya Copyright Board, and they are agreed upon and gazetted. And I think maybe having that kind of tariff, and saying, this is the amendment that we are saying, that whatever it is you collect, 70% of it must go to the artist. That is what I would lobby for, as both as an artist and as an intellectual property expert, because in definitions, and like I said, if something is not in writing, then it is very difficult to implement it. And of course, because this is copyright is a private right. However, the Kenya Copyright Board and the government bodies that oversee copyright are the ones that are charged with, sort of regulating how it is that we work. And those are the bodies that we must then look to create that framework that will allow the content creator, to be able to demand from these private telcos, private companies, and private users of your content, to pay you what you need. But again, also it's also the power of negotiation, because when I teach copyright in my classes, that there was a time, the birth of copyright and the birth of content creation, whether it was music or and this was specifically music in the early, this was the time of the Great Depression, and this is in the US. And they were putting music on radio. And then, the artist said, no, we're not going to put the music on radio. And then stopped. And you see, without music on radio, then you do not have the thing that brings the audience onto. So I think collectively, working collectively is definitely the way that we move forward for content creators. And yes, so that amendment for that kind of revenue split, as part of the tariffs, in the way that the tariffs are looked at, because there was also the other thing that the copyright board did was to encourage the CMOs to work together, so that the hotels and the bars are not paying to three different CMOs, so that you have one and then you split it between the three or four or five, because of course there's a number of CMOs, and depending on which body of creator that they're dealing with. So I think that would be the way to go. But amendments are not they don't happen like that. They have to be moved. There has to be interest in getting that. It has to be drafted. So there's a long bureaucratic process that takes place. There's a lot of bureaucracy in getting those amendments through. But I think being consistent and being very, very clear with what it is that is needed, and having committed groups of people. I think if the content creators got together, then it will be very easy to move forward.
Okay, great. So I'll let you take a breather as we shift gears a bit and go into now, copyright issues. There's a lot that is happening in the digital space, content going viral, to concerns about privacy, infringement of IP, and monetization. So I got myself a copy of Michael Onsando's newest book. It's called The Perilous Journey to Beyond My Nose. This is his third poetry collection, and it is available at Kwani. So make sure you get yourself a copy. I am still trying to get Michael to. We'll see which of the episodes he will be coming in, because I'd really love to, for him to talk about this, and for us to sort of go through the poetry that he has written and his poetry journey. So coming back to the second part of our discussion now. There is an article that we co-wrote. I started on it, and I reached out to you because I wanted your take as an IP expert, and this is around content that is going viral on social media. So a very recent example is the Ugali Man, and I'm sure a lot of people have hailed it. It's a good thing. The guy is. He's gotten a very good endorsement with a betting company, and all because he shared a video of him eating ugali. Who would have thought? That in this day and age, a video of you eating ugali would,
Though in a creative way, though. Who would have thought?
It's the creativity.
It was the creative way in which he ate the ugali. Yes.
It's true. Yes. It's the creative way in which, and I've seen, there's a certain musician who tried, that whole concept again. And the internet culture in Kenya has grown, like from the time that we discovered blogging to opening our first account on Twitter and on Facebook, getting onto Instagram. That was I think around the early 2000s. A lot has changed, and so what we're seeing, and this is the article that I wrote for Global Voices on Kenya's internet shifting culture, and how content creators are now able to monetize their content, but then there are concerns, and that's why I reached out to you. Concerns about about copyright, about privacy. Yeah. And so I'd like us to start with what are the other arising copyright issues as more creative works are shared or published on digital online platforms?
For me, I think I think shared it on the article also, because the premise of copyright is I have created something new, and therefore I should be paid for doing this
Mhm.
wonderful thing that I just created. And for me, one of the concerns for me, and it's probably from a creative point of view, is originality. For example, so we saw Ugali Man doing his thing, and now we all want to do it. And when we all do it, when I'm getting paid
Mhm.
for doing the Ugali Man parody, is that really fair, or should there be a way in which Ugali Man also gets paid for creating
Yes,
this new thing?
talking of which now it's sort of it has come to mind
Yes,
is the song Firirinda
yes,
and the dance.
yes.
And I remember, that guy and complaining and saying, "I'm not getting anything out of it. Everyone is doing their TikTok renditions of Firirinda, but he was not getting the royalties."
Yes.
So I mean, what happens?
And for me, I think it's also the technical the wonderfulness of the internet is also the thing that makes it difficult to sort of like police where it is that you get this revenue from.
Mm.
And it's really up to the content creator to put either the platform on notice that yes, I have used this song from this person, and therefore this does not belong to me, and therefore the monetization maybe split would maybe that if there is a split at all, or if the song belongs to so and so. And then, because
Mhm.
depending on the platform, they do not pay you for work that doesn't belong to you. So
Oh, so
yes.
now it was for the musician who did Firirinda to go onto all these platforms, whether it's TikTok or YouTube or whichever platform, and claim ownership of that song.
Yes, I mean, and of course, the ownership of the song is not in dispute. It is, where is it, so that it is in that um, because they do have databases where they run through. So, for example, if you put in, you remember there was a national anthem debacle where people were saying, the national anthem belongs to, I don't know, some you
Mhm.
know person that had recorded. But you see, that sound recording belongs to whoever it is who made that sound recording. So in
Yes.
in, in copyright, especially in a musical work, there's the sound recording itself, which has its own copyright. The
The
lyrics, the
composition.
composition itself, the arrangement, that has its own
Mhm.
lyrics, its own copyright. So even in the understanding of how the copyright works, they're one piece of one musical work can
Mhm.
have different owners, and those different owners then would then benefit from the exploitation of
Ah.
that work. But of course, artwork and all these other sorts of mediums still have different ways of being interpreted. But musical works actually are the ones that really bring the most noise. If I sample a piece of your music and put it in my music, it
Mhm.
means I have created something new, but based on something that you created. Therefore, we should be sharing
Mhm.
what the benefits of mine is, because I made it
As the
of
original
yours.
creator,
Exactly.
yes.
But we have, I feel that we have really moved forward in terms of um being able as creators to reach a global market very easily. What we need, I think, to do is to fine tune how it is we understand these spaces, and understand what ways we can exploit, and then honor those
Mhm.
who have created before us, so that we are all walking into the door of plenty together.
Mm-hmm.
Yeah.
Yeah.
Mm.
And I mean, coming to the question on, signing endorsements.
Yes.
Um, Now, should content creators be celebrating, or they're still getting the short end of the stick?
I celebrate when anyone makes money. Me, I'm celebrating because, 15 years ago, 20 years ago, this was unheard of. And I like to look at life, first of all, that we have a glass. Let's start there. I look at the glass half full. So we are in the glass half full position, because if we focus on the emptiness, then the glass can also fall. So let us be happy that there is a glass in the first place. I am excited that brands are also looking at content creators as movers of their brand love. And the thing about being a content creator, if you create something and you get paid for it, that's a celebration. Because if we cannot count the number of at least musicians who have left this earth in less than nice circumstances,
That's
based off somebody else benefiting from them. And if we can have this trend move into spaces where we are seeing a content creator actually living a very, very comfortable life, then I think we'll have won, and I think we are headed there.
I think
are
so
headed
too,
there.
because I
Yeah.
think even I think part of the section of the article, what I started with is we are seeing a shift in the corporate world and the advertising world, what their focus has been in terms of the models for the endorsement of their products. So
Exactly.
previously, it used to be, it has to be a TV personality, it has to be a musician, and so every billboard that you look at, it is either one of those. But then now we're seeing a change in, and it started with the lady who was saying serikali saidia, and it was, I think, about 3 of them, is it 3 or 4, that were picked by Safaricom, and that is what sort of marked the start of what we are seeing now. Because there was the lady, the kifi kifi lady, then there was Nikama drama, Nikama video,
Yes.
and those guys now have become household names, because there's a documentary that was done later, I think about 5 years later, because I think this was in around we're in 2021, around 2016 there.
Yes.
And there was a documentary that was done, 4 years later, to look at how did their lives change. And you can tell there's been a total transformation. Their lives have improved. That was a turning point in their lives. And I love that, what is happening, but it's also good to also be aware of what are some of the concerns and some of the things that are coming up, and that is what we're discussing.
Yeah.
And one of the things that I wanted you to talk about is the concerns around privacy, especially when minors are involved. Now, in the article, again, I gave the story of this girl called Amani, and
She's
how
very talented.
she
really
is.
She really is.
She is really talented, and I'm really glad that this story has a happy ending.
Yes.
There were a bit of, there were some things that happened that were not ugly along the way, but it sort of becomes the question of the egg and the chicken.
Yes.
Now, had the American lady who took the video that went viral of Amani singing Alicia Keys' rendition, if she had not taken that video, we probably not even know that Amani existed.
Yeah.
But then there was no consent from the parents.
Exactly.
Where does that?
And I think this is the thing about like I said, it has wonderful things. The internet has wonderful things about it, but I feel that even as we do this, even as we create content, and as we are excited about it, I think the protection of children in these spaces is really important. I remember one time being at in the wonderful time when we were outside our counties. I was in Diani, and some person came and took a picture of my son. And and my son was just just being himself on the beach. And I assume if he was singing or whatever it is, that would have been something that would have possibly happen, and
Same. Yeah.
he is who he is. However, of course, I, as the parent, went and demanded that the said person delete
Deletes the photo.
deletes the photo, because there was
Mhm.
no consent, and the children were just playing by themselves by the beach. I was not that close, but I was close enough for me to come and say, what are you doing? And these are the things around children and protection of, because what is in the best interests of the children. The internet has its if you've been on Twitter, if you've been on Instagram, you know how things can spiral into negativity, and the psychological impact of that is actually being seen in Korea, in all these spaces where
Yeah.
internet is what determines whether a child will live or not, because of how they see themselves. And I think, as the adults, we need to take responsibility for those who cannot make those decisions for themselves. But at the same time, I think it's that delicate balance around figuring out, is this good for the child? Is
Mhm.
this good for the society? Is this good for the future of this child? Because one would argue, I think there's like a 6-year-old child who does this unboxing of toys and makes a lot of
Mhm.
YouTube money
Yeah.
doing that. But in my mind, I look at that kid, and I ask myself, yes, he's making the money, but what does that mean for him? Will he ever, walk on the street without being known? Will he know what work is? Because if
Mhm.
his work is to undo toys, like
Yeah.
unbox toys,
Yeah.
and he makes money off that,
Mhm.
what does that
And
mean for
yeah. And
for what he interprets to as work? So I think it's really a delicate balance for a parent, to figure out if that's great for her money. She got signed, and she's done quite a bit of work. She's in school. She signed to a great label, and she has a great future ahead. But of course, her mother is
mhm.
always with her, which
Yes.
is and for me, I admire that she took lessons with one of our teachers at the Conservatoire. And I think it's important for us to just sort of protect this children, and protect how we expose them, because the internet is good and bad,
Yeah.
for them. But then, if you're going to make money, then let's make money safely.
Mhm.
Yeah.
Okay. And as we conclude, what are some of the common copyright and copyright infringement in Kenya that we've seen? But as you take that question, I just wanted to sort of say that I resonate a lot with what you've said around children, because for us as content creators, having seen the beauty of having that freedom to create content, have your own platform, become an influencer, that can sometimes get you get your head in the clouds, and you sort of forget that you have a responsibility to your children, and they will get to an age where they will ask you, Mom, why did you post so many photos of me and I didn't want? That is
Exactly.
a question I don't want my children to ask me, because
Exactly.
it becomes it becomes, and here it becomes very problematic, because you probably have a child who will grow up and they do not want to be a very public figure, but you as a parent are. So how do you grapple with that as a parent?
Exactly.
So I mean, it's we live in a free society, so if you can be able to reconcile yourself with that,
Yeah.
but it's good to think about that, even as the children grow up.
And also in monetization, for example, I feel like, we talk about child labor. So child labor is, outlawed everywhere, WTO. We don't talk about child labor, but what
Mm.
parts of our consumption of this content is child labor?
Oh,
These are, those are
now
now
you bring in a
conversations.
very that is controversial, because they are actually creating content and they're working because they're earning a living.
Yeah.
So where do you draw the line?
Where do you draw the line? And should children be working? These are conversations that that can go. This is a string,
But you know,
from my yarn.
we're having those likes and everyone following is such an awesome thing.
And the thing about followers, that's the other thing. I mean, there's a lot of talk about mental health and talking about what these spaces are doing for mental health of adults. And so what does this mean for mental health for
For
children?
children.
And content creation and monetization and get me money is great for adults. But what does that do to a child when they have to earn money and when they have to do videos and they have to do as much as they can to get their likes? Because you see, it's really about the likes. There's quite a number of interesting scenarios that have been painted in content that has been created about this life that we're going into of likes and the flakiness of it.
Yeah.
But that's a social construct. But in when it comes to copyright, like I said, I would draw a string also into, are we talking child labor where children are concerned? And should we be allowing this? And should there be a limitation as to what it is, what constitutes child labor, and what do we then define as? Because again, if a child is talented, then they should make money off it. There have been child TV stars. There have been child prodigies. You know that there have been children doing a lot of things, and they've been earning money for a long time. But how do we safely create that space that takes into account all those things that we're talking about?
Yeah. Okay. Great. So as we come to the end of our discussion, I know there's a lot to talk about.
There is.
But what are some of the common copyright and IP infringement cases that we've seen in Kenya lately?
I think the bigger ones I see right now are I mean, people using other people's work. I mean, you've experienced it.
Oh yes.
You've
Oh,
experienced
and that court case dragged on. Finally, we settled out of court, but yeah,
Fortunately,
yes. And I think it's because of me being in the public space and the case becoming very well known in the public space. I think the party involved felt they needed to settle this quickly
and sort it out.
Yeah.
And I think so. People using other people's work is very common, and I think for me, even you know, companies, brands, not recognizing. The work that has been put in, you know, I think over several elections, people have taken people's pictures, used them for their campaigns, and you know, so photographers, musicians included, you know, poets, writers. There is a culture of taking and not paying. And for those who are in the know, they do get to have the conversations and do get representation and do get into those conversations. But then for those who do not, there is that bitter feeling where somebody, you know, has taken your work and you didn't get paid for it. My hope, even as we're talking about, you know, infringement, for me is getting ourselves into the education stage where we are educating people from the earliest age. I think the opportunity in the new CBC curriculum is one of those, where we now start talking about, you know, you owning, you know, you create a piece of work, your artwork, and yes, it belongs to me. Let's have kids signing their work. Let's have kids recognizing, oh, I put a little bit of this person's work in my work, and therefore this is our work. So like teaching intellectual property concepts from a very early age, so that by the time, you know, we're having 18, 19-year-olds creating great inventions, they are talking about working together and being part of groups and not trying to, you know, remove you know, co-creators, but then also as a brand policy for, you know, this big corporates. I feel that there is space for there to be, you know, when they talk about CSR, and they talk about, you know, institutional culture, I even think even in the kind of politicians and in the kind of campaigns that we have, let's have conversations about, this is the kind of politician that I am. This is the value that I give to the people who create for me. And when we begin to sort of change the culture in which we think about content creators and people who add beauty into our lives, then we will also change how the revenue model works. Because if I already, as a creator, I'm proud to put my name on it, and I am proud to put somebody else's name on it who has assisted me or has worked with me, and then I will also pay you,
Yes.
my fellow content creator. I will use your
Mhm.
poem in my song, and I say lyrics by Njeri. And I will always, even as a creator, honor that. I think it's just, it to me it feels like, it all starts with you. So if you do the right thing, and the next person does the right thing, then we just have an avalanche of
Yeah.
good things.
Awesome,
Hmm.
awesome. And
Yeah.
thank you so much, Wandiri, for coming in and for, your take on and just helping us understand this whole, copyright and IP law. And I'm hoping that for our listeners out there and for our viewers that you have enjoyed this conversation. You can find Wandiri on the various social platforms. Which one are you most active in?
Well, Wandiri Karimi, that's my name. I'm on LinkedIn. I'm on Twitter rarely. Twitter is jungle, but yes, I'm there. Sometimes I'm on Instagram. I'm
Okay.
yeah,
Okay,
yeah.
great. So you can find her online. So
Mm.
it's been great having her, and I hope that you've enjoyed the show. Until the next episode, kwaherini.